Hello, hello. Good afternoon, everybody. Happy November and happy holidays. We're so glad you could join us today. I am Tammy Welty. I'm the Director of Training and Communications here at Bradford and Barthel. Actually, you know what? I'm going to hand it over to Tamina first to say hi, and then I'm going to start with that. Thanks, Tia.
You forgot me, Tammy.
I
Good
did.
morning or good afternoon, everybody. My name is Tamina Ahmed, and I'm the managing partner for client relations with Bradford and Barthel. I appreciate being on today, and this is going to be a great presentation. First of all, I do want to wish Tammy Welty, who's part of my team, a very happy anniversary. Congratulations, Tammy. Great job. I also, as we're coming upon my favorite holiday, I want to take a moment to express my gratitude for everyone who is responsible for making Bradford and Barthel the incredible place that it is today. So thank you all for everything that you do every day. And that includes my wonderful team of marketing directors. Thank you so much for spending another year with me, and it's been amazing. And I cannot believe we're already getting close to the end of the year. I also want to acknowledge the incredible people we deal with every day. That's all of you, our clients, our employers, our brokers. You are deeply valued. We thank you for joining us on this journey, and we look forward to working with you next year as well. So thank you, and let me pass it back to Tammy.
Thank you, Tia. We have Nasser Adil assisting with questions today. Nasir is an equity partner and the managing attorney of our Oakland office. He started his workers' compensation career with Bradford and Barthel back in 2009. You might recognize Nasir as he is the host of the B&B Comp Corner podcast. Nasir, I heard that we're going to be releasing an emergency podcast this week, and I also heard that people can now earn CE credits for listening. Will you tell us a little bit about this important podcast?
The rumors are true, Tammy. We are now offering, hello, everyone. Good afternoon. My name is Nasir. Thanks for joining, everyone. Tammy is correct. I have the privilege of hosting our firm's podcast called Comp Corner. We have 8 episodes up on Spotify, Amazon Music, as well as Apple Pods. We have an emergency podcast coming out tomorrow. It's an emergency because we have the honor of having Louis Laris and John Kamin. They are both on the episode, and we're focused on Rodriguez and the recent District Court of Appeal decision in our favor. So we're very excited for that to come out tomorrow. CE credits will be offered for that episode, and we're now doing a pivot where we're also going to be doing episodes specifically for CE credits. We have 8 episodes up already that are podcasts that are talking about different topics already. So please check us out if you have not already done so. Episode 6, well, we had the pleasure of having John on that episode. So that was a real fun one as well. We talk about John's experience with the editorial board, blogs, his poker background, and of course, many other things. So thanks again, everyone. Looking forward to getting your questions and answering and interrupting John throughout the webinar today. And back to you, Tammy.
Thank you. Today's speaker, John Kamin, is an equity partner out of our Woodland Hills location. This is his 10th year teaching our annual legislative update, which I think is pretty cool. John was awarded Defense Attorney of the Year in September by the Workers' Compensation section of the California Lawyers Association. Additionally, he took the Rodriguez case to trial, and our very own Louis Laris, as Nasser just mentioned, won that case at the second DCA. So John will talk a little bit about that case at the beginning of this presentation, but I just want to say, don't you all think John has had an incredible year? Congratulations, John. We're all very excited for you. John is also the director of our editorial board, aka our blog, and I think John's going to tell us a little bit about that blog and then roll into his presentation. Thanks, John.
Thank you so much, Tammy. Yeah, that's hard to follow that intro. So you set it up very well. But yeah, thank you everyone for showing up today. I'm a equity partner in the Woodland Hills office. And before I came to Bradford and Barthel, I was legal editor at Work Comp Central for about 6 years. As Tammy said, I'm director of the editorial board, which is a fancy way of saying I run the firm's blog. And we do have a blog article that's going to be posted today it's the blog article version of the legislative recap. So it has little descriptors of all the bills we're talking about today. And also links to those bills as well. So you can just click on the hot link, the bill name, and it'll take you right to the actual text on the legislature's website, which is good because then you can just scroll down to the section that you want to see and go right to the text that you need. And so we will have more blogs rolling out in the next month and a half. And please send us your blog articles. Our best blog articles come from you, our clients, and our audience. One fun fact about myself, and I think it's pertinent in light of the Rodriguez decision, which I think we can all agree is a big win for the firm and for the defense bar. Well, one of the toughest things after a big win, whether it's a great hole in golf where you got a birdie or an eagle, or you win a poker tournament, is the next one, the next hole in golf or the next poker tournament. And often people follow up a birdie or eagle with a double bogey, which is bad, or triple bogey. So you go from superior results to not so great. So anyway, we know that. And so we are definitely trying to work harder after our big wins to try and offset and avoid the disappointing double bogeys of the world. So with that being said, let's get started. And we are going to focus on the Rodriguez decision first. And then we'll go into biggest issues in 2025 that we talked about on the blog that could lead into 2026 legislative session. Then we'll cover the many smaller bills. There's about 15 of them that were signed into law in 2025. And then stalled bills, which we may see in future sessions. Every year, there's a few bills that get stalled in the legislative process or held in committee with the intent of being brought up again in the next year. So we'll touch on a few of those. And then we have another brief case law update on another appellate court decision that we also thought was newsworthy. So with that being said, let's jump right in. The Rodriguez decision was argued by Bradford and Barthel's appellate specialist, Louis Laris, at the Second District Court of Appeal. And yours truly, I was the attorney who handled the trial and the reconsideration with Louis's help. The Rodriguez decision is a published decision from the Second District, which means you can cite it. It came out on November 10th, and it applies to cases with Patterson issues. And it basically does away with the Patterson doctrine. If you don't know what that is, that's okay. A lot of people don't, so don't worry about that. But basically, the Patterson doctrine is what we would describe as an end run around the UR and IMR process. And those were brought up in the 2004 legislature's Senate Bill 899, which made those a mandatory process of workers' comp. So the Patterson problem, or the Patterson doctrine, it bars carriers from sending a request for authorization to utilization review when these two things have happened. When the defendant has already authorized the treatment in the past, and there has not been a change in condition since then. And so in order to send stuff to UR, the Patterson doctrine would say, defendant, you now have the burden of proof to prove a change in condition. And so that burden of proof would fall upon us. We'd have to have evidence that the change in condition occurred. And the problem with that is that the change in condition was never defined. So how can you prove something that you don't know the definition of? Another problem with it is that the primary treating physicians who are working on behalf of the applicant's attorney have little to no incentive to stop recommending care. And then you would look at also, well, what about QME reports? Could those show a change in condition? Some judges were telling us, no, you can't use QMEs in medical treatment disputes, and they'd cite the Sandhagen case. So proving a change in condition was always nebulous. We would get back decisions saying that thing that you're arguing is a change in condition is not a change. And as you know, medical conditions change all the time. So for example, if you think about a cold or a flu that lasts, let's say, 7 days, day 1 is going to be different than day 6. Day 2 will be different than day 7. Severity of symptoms change over time. So anyway, those are some of the issues with proving that. At the trial level, the applicant's attorney filed for an expedited hearing, arguing that the client, the defendant, could not send a RFA to home care or RFA to UR for a decision on home care. The applicant's attorney argued that the Patterson doctrine applied and that there hasn't been a change in condition since the defendant previously authorized home care. So in other words, you can't send that RFA to utilization review. The defendant, I argued, hey, the defendant has a timely UR denial, and there also has been a change in condition. In fact, in this case, the PTP reports were saying that the applicant was too reliant on the home health aide. We also pointed out that the home health aide was recommended to prevent seizures in case the applicant had a seizure at home. Yet the applicant hadn't had a seizure in years because his anti-seizure medications were working very well. Despite those arguments, the judge ruled for the applicant's attorney, said there isn't a change in condition, and defendant, you couldn't have sent that RFA to UR, you were barred by the Patterson doctrine. So we filed a petition for reconsideration in 2020. The appeals board issued a grant and study decision, which grants reconsideration but allows more time to review. In 2024, the appeals board ordered the parties to mediation to try and settle the case. The parties discussed settlement but did not settle. And then the appeals board affirmed the decision in January 2025. So then we filed a petition for writ of review with the Second District Court of Appeal. They grant review after determining that the petition for reconsideration was timely. Oral arguments occurred last month, about a month ago. And the holding by the Second District Court of Appeal is that these medical treatment disputes must go through UR and IMR, even if the defendant has already authorized the care at some point in the past. And another part of their holding was, the stuff about the burden of proof and change of condition. Well, the appellate court called those extra statutory proceedings at the appeals board and said that, you can't have those. Those aren't mentioned by the utilization and IMR statutes. So in other words, you don't need those extra proceedings, and defendants do have the right to send those RFAs to UR. Now, please note that there still is time for applicant's attorney to appeal, and we anticipate that they will file a petition for review with the state Supreme Court. Keep in mind, the state Supreme Court grants review to very few cases due to the large number of criminal and civil appeals. As most of you know, the High Court doesn't really like touching work comp. Criminal stuff by far outweighs civil, and the hierarchy of cases that they look at, people's freedom is right on top. And so I think the High Court, rightfully so, gives more weight to criminal matters first, and then kind of looks at everything else that's coming in. So what if they deny review? Well, if they deny review, then that Second District Court of Appeal published decision would stand. And one other factor that may impact the High Court's decision whether to grant review or not is that there's no conflicting case law in other district courts of appeal. So when there is conflicting cases in this district versus that district, the High Court does like to grant review. But when there's only one ruling in one district and there's nothing else conflicting, then the High Court is less likely to grant review. So that bodes well for Rodriguez standing. Assuming that the decision does stand, defendants would no longer be punished for authorizing care because they don't have to fear having authorized it forever, absent proof of a change in condition. Another result is that there's going to be fewer expedited hearings at the appeals board on Patterson issues. If there is no Patterson doctrine, fewer expedited hearings. And some of the boards have really, really clogged calendars. Some of them are scheduling 6 months out. Another result, if this decision stands, is that there could be lower costs, but that also depends on UR. Just because you're sending something to UR, they could authorize it. So we'll have to see how that plays out, if costs go lower, stay the same, or still go higher. And on that note, the UR system still has doctors across the spectrum. I see plenty of PTPs and lean doctors writing UR decisions. So That's another thing that makes UR still unpredictable. So let's move on to two themes that we wrote about on the blog a lot in 2025. Those two themes, and these are going to carry into 2026, are the WCIRB warning of higher cost across the board. In other words, defendants are paying more than ever before. Their loss ratios are bad. And we'll jump into that a little more. The other big topic of 2025 is similar, touches on some of the same stuff, that SIBTF, or Subsequent Injuries Benefits Trust Fund, which is the state's version of the Second Injury Fund, is spiraling out of control, and that got Governor Newsom's attention. So those are two big topics this year, and you'll hear more about them next year. First, on higher costs, the WCIRB, which is the organization that recommends the premium rates for California, they've been ringing the alarm bells all year, warning of higher costs across the board. Insurers are steadily losing money. Loss ratios are starting to look like the ones from 20 to 25 years ago, which is bad. Claim severity is up, medical spend is up, and when carriers' costs start to get too high, they leave the state. For example, we've all seen that with fire insurance, and it's even starting to happen with auto insurance. My longtime insurer of 15 plus years just left California, and they're a big one too. So that's what happens when costs get too high. Insurers stop writing in California. And so when costs start to get too high, wild things really do happen. Carriers go insolvent. That causes SIGA's caseload to go up. SCIF's market share jumped because SCIF will insure when nobody else is. And so, for example, 15 years ago, State Fund's market share, we were seeing it go higher than ever before. And since then, it's gone down as more carriers were writing in the state. Another side effect is that premiums go higher, and that causes employers to complain. And then employer lobbies are, pretty big, and they start to vote differently in unpredictable ways too. So it causes a lot of issues. That voting differently got Gray Davis recalled about 20 years ago. And then Governor Arnold Schwarzenegger goes into office, wins that recall election. And then we get emergency legislation that affects all of work comp. And then there's more litigation, for years over Senate Bill 899. And if you look at Patterson, that goes back to utilization review. So even Patterson is kind of challenging a provision of Senate Bill 899, which was passed 20 years ago. So higher costs cause all kinds of unpredictable effects across the entire workers' compensation market. And so that's why I wouldn't be surprised if Governor Newsom takes a look at that next year in his last year in office as California governor. Another thing is the SIBTF. For those of you who don't know, and a lot of people don't know about the SIBTF because they don't have to deal with it, an applicant can get benefits from the SIBTF by proving that they have a pre-existing injury, a second injury, and that the combination of the two equals a life pension case, 70% PD or more. And states had created these second injury funds, so not just California, but a lot of states, to help encourage World War II veterans to return to work after the war. Then that way, if they got hurt at work, there was some money for them when their work injuries combined with their war injuries. Now, one trend we saw, and Governor Newsom even referenced this, is that some states did away with their second injury funds because their costs got too high. So throughout 2025, Governor Newsom warned in his budget proposals and also in his veto message of a SIBTF bill that something has to be done to fix that fund, or else maybe California will delete it. There was a bill proposed on that this year, but it did not go far enough, and Governor Newsom vetoed it. So here's some of the cost, for example. Employer assessments, which pay for the fund, started at $14 million in 2015. By 2029, 2030, the yearly assessment could cost as much as $1.3 billion. So when we talk about skyrocketing cost, and skyrocketing employer assessments, and the math is astronomical. And so Newsom already said that in 2026, he does intend to push for some major SIBTF reform legislation. And if carriers and employers are paying higher costs, you could see some omnibus legislation, in other words, just general wide-ranging legislation cutting down costs. If friction costs, like litigation cost, subpoena cost, med legal report costs, get more controlled, then maybe SIBTF could see some relief as well. So with that being said, let's look at our 2025 recap of bills that were signed into law. So the bills on the next set of slides are bills that are now law, and most of these take effect on January 1st, 2026. Of these, the QME reporting bill is probably the biggest change, so we'll jump right into that. The QME template bill, which you may have heard about, is Assembly Bill 1293, and it calls for the DWC to make a joint medical evaluation request form, a template form for QME reports, and that's to help QMEs include all necessary requirements. They touched on all the right topics in their report. And the bill also requires the DWC to establish a method for grading the quality of QME reporting, which would also include standards on whether the reports are incomplete or whether the reports are insubstantial evidence on stuff like PD or apportionment. So some of the pros of this bill, looking at it in a positive light, that joint medical evaluation request form could eliminate some gamesmanship with setting up the QME evaluation. And what I'm referring to is some applicants' attorneys want to set it at a super early date, which then makes it difficult to abide by the laws, the 20-day rule that you have to give your opposing party a chance to object, 15 days to object, and you can't send out that proposed QME letter until after 20 days. So in other words, having dates that both parties agree on eliminates some of those problems. And then also a QME report template could encourage more detailed reports that address all the issues. And what I'm referring to is, for instance, how many times have you seen a QME report that talks about everything, but then forgot to talk about one thing? And now you need a supplemental report or you need to take a doctor depot. It seems more often than not that one forgotten topic is temporary disability. What were the periods of temporary disability? That's a pretty important issue. So on the bright side, maybe this bill helps encourage QMEs to write more complete reports. As far as some of the cons, you don't always need a QME to comment on every single topic either. When you ask for a supplemental report, for example, sometimes you just need clarification on one or two issues. And also with the creation of any new regulation, and there are going to be new regulations to define how these forms are used and explain deadlines and stuff like that. Sometimes the creation of new regs can create new areas for gamesmanship as well. And smart parties can figure out ways to exploit them to their advantage. Another issue is that the last part of that bill, the third bullet point, could be used to attack non-industrial apportionment, specifically if the grading system is designed in such a way that punishes one side more than the other. It could also punish applicants as well if it's finding that the PD in way too many reports is not well defined. So that could be a double-edged sword. So we'll have to see how that plays out. We don't know how that's going to play out just yet. So moving on to our next bill, Senate Bill 291. This bill requires the Contractors State Licensing Board to mention in its annual report any actions it has taken against illegally uninsured contractors. And it also creates an audit or verification process for that same board to confirm whether contractors without employees are actually exempt from the workers' compensation requirement. And what I'm referring to there is contractors who need a contracting license. They file their filings with the CSLB, that board, saying, I don't have any employees, but it's not true when you actually look at it. And then they say, well, because I don't have any employees, I don't need to pay workers' comp premiums. but they do actually have employees when you examine more closely. So that's what that audit verification process would be. It would exist to, find out if contractors are not being straightforward or honest about whether they actually do have zero employees. And another element of this bill is that the minimum civil penalty would be $10,000 for lack of workers' compensation coverage. So if a contractor is being shady and they should have gotten coverage, but they did not, they could face a five-figure bill. Moving on, and these next few slides also touch on similar issues. So, for example, Senate Bill 847 allows the Division of Workers' Comp to determine if the sale of an uninsured employer's property was done to protect that asset and avoid workers' comp liability attaching to that asset. So, for example, if they sell a building to try and hide that asset and pocket the money, the DWC has the authority under this bill to say, well, yes, we think that they did do that to avoid liability, and we're going to place a lien on the proceeds from that real estate transaction. So basically, this bill gives the DWC a little more power to pursue uninsured employers' assets. Senate Bill 779 increases minimum civil penalties for unlicensed contractors. That would now be minimum civil penalties of $1,500, which is increased from $200. And then other similar related penalties would increase from $500 to about $1,500. And while we're talking about contractors, let's touch on this bill, Senate Bill 517, which adds a provision to home improvement contracts. These contracts would have to state whether a subcontractor will be used on a project. And this should make it clear for homeowners who are hiring a contractor to work on their home, whether a subcontractor is going to be used and whether that certificate of liability, the work comp coverage is going to cover them. Now, these home improvement contracts already do contain a state mandated work comp coverage provision. But if you see that there's an extra subcontractor being used, the homeowner may want to inquire as to whether the work comp coverage is going to apply to them. And it's good for homeowners to ask those questions because you don't want to be sued if someone gets injured while working on your home. That's no fun. While we're talking about companies that misclassify employees, this bill gives trucking companies that have misclassified their drivers until January 1st, 2029 to properly classify their drivers as employees under a trucking amnesty program. Now, the prior deadline in the state laws was way back in 2017. So if a trucking company has been classifying their drivers as independent contractors, realizes under the ABC test that may be incorrect, then they may want to make this shift and classify their drivers as employees. Doing that could avoid additional civil penalties in the future, but doing that also means agreeing to indemnify employee truckers for the cost of their truck or tractor trailer and the upkeep of that stuff. So if a trucker's tractor trailer gets destroyed in an accident, they have to indemnify that, and that's additional cost and liability that they're taking on as well. And Nasir, do we have a question?
Yeah, thanks, John. We've been light on questions, but I did want to interject and kind of make sure that we touch base on a recommendation from Clay Jackson about making sure Thanksgiving is acknowledged for Black Angus. So light question and answer session so far. No questions really come in about case law, but Black Angus is recommended, and more Thanksgiving updates regarding Reynolds bags will crisp the turkey, but Tamina has confirmed for Mr. Herbert Bermudez that it's recommended that to remove the bag in order to get a fully crisp. So questions are light, but if anyone has any questions, feel free to chat them in and we'll interrupt John along the way. If not, no sweat. John's doing a great job. Thanks, John.
Thank you. And yes, I thank you, Clay. I can definitely second the Black Angus. That was my law school's post-school hangout place. So yeah, The one in Ventura is going to reopen soon, but yeah, you can always find some law students there. So moving on to Assembly Bill 1514, pertaining to exemptions to the ABC test. The ABC test was codified into law several years ago, making it easier for courts to determine whether a worker was an employee. So this bill exempts manicurists and extends the exemption for commercial fishermen as well from being labeled as employees under the test. So manicurists and commercial fishermen are exempt from the ABC test for at least a few more years. And moving on, Assembly Bill 1398 requires physicians to disclose a financial interest in the entity that's receiving a referral. So they must do this in writing, and they must disclose that to third-party payers. If they don't do that under this bill, that would be a misdemeanor. And so an example of how that would work under this bill, Dr. Spock issues a referral for MRIs at their favorite clinic, Clinic du Jour. But Dr. Spock's brother owns Clinic du Jour. Now, Dr. Spock has to notify the TPA in writing about the relationship when they send over their bill. And that referral would appear to be unlawful under Labor Code Section 139.32 anyways. But that is an example of how that would play out. So that disclosure is supposed to be made when the physician sends over their invoice. Now switching topics a little bit to
All
Senate
right,
Bill
John, can I, before you do switch topics, good question that just came in. I figure might as well be relevant on this topic. A few questions that came in. Thank you, Lalisa Tillis and Gabrielle Petre. Hopefully, I'm not mispronouncing those names too much. Similar questions about any legislation pending for temporary agencies and lack of coverage like that of the contractors that was outlined. If you know that, if you want to expand. Similar question from Gabriel about any legislation in the future to hold uninsured temporary services responsible for their workers' injuries rather than naming the company are signed to pick up benefits. So if you can expand, please do so. Thanks for the questions.
Certainly. And so there was legislation proposed, and I can hop down there on that topic. The bill stalled in 2025. And so I think it's not quite staffing agencies, but this bill that was proposed, and it's not law, this one's stalled, but we could see it come up again next year. It would have required PEOs to register with the Department of Labor Standards and Enforcement. And any PEOs would have to pay an annual fee. And the goal was to encourage the PEOs, the shadier ones, because not all are shady, some are above board and do an excellent job. But the ones who don't do a good job and are trying to hide employees and push liability elsewhere and skimp on coverage, it was to encourage those PEOs to put some skin in the game with an annual fee. And also put them on record with a formal filing with the state. Now, that Department of Labor Standards, they handle wage and hour complaints under the Labor Code. So those shadier PEOs who were trying to evade sunlight and sunshine, it would have put more of the bureaucracy's flashlight on them to expose some wrongdoing. And so there has been this interest in PEOs and staffing agencies over the years. And I think that may be something we could see more of in 2026. And so that's why I did have that on slide 45. And just on a different note, while we're talking about that topic, I did see an email from RJN Investigations advising about an update about the folks from Barron HR. And let me just pull that up. So the Orange County District Attorney's Office did secure a conviction for workers' compensation premium fraud and obtained over $138,000 in court-ordered restitution. And so what they're talking about is the case of People versus California versus L. Perez, the owner of Barron HR, and several other staffing subsidiaries. And so the Orange County DA obtained restitution for insurance carriers of about $140,000, just under that, as well as $43,908 to the California EDD. And that restitution, I'm skeptical as to whether that's ever going to get paid, because Mr. Perez is already serving a 8-year prison term based upon a federal conviction, and where he is ordered to pay back the IRS in excess of 30 million bucks. So as part of the federal case, they ID'd various assets which were seized and sold, such as a Lamborghini, a Rolls-Royce sedan, private jet, and a yacht. Personally, I'd go for the private jet. What about you, Nasir?
Private jet all the way, no doubt. Yeah.
Oh, and there was a 10,000 square foot home. That's no small potatoes either. But thank you, RJN, for sharing that. And so maybe we will see more successful prosecutions like that in the future, for folks who are trying to play outside of the rules and outside the requirement to have workers' compensation coverage. So definitely a good question and a topic we could see more of in 2026. One interesting bill, and we're shifting a little bit now to subrogation and firefighters, police officers. So this bill is known as the anti-subrogation bill, and it makes it harder for cities and counties and local government to subrogate against police officers and firefighters' third-party suits. And this especially is going to come up when the offending third-party motorist, in other words, the bad driver who drives into the cop or drives into the firefighter, when that motorist has a low policy limit. So the intention of this bill, which is signed into law, is to protect cops and firefighters from not being made whole when they put themselves at greater risk than everyone else, by being out there on the roadways every day. So this bill says that a police officer or firefighter shall receive no less than 2/3 of a third party's defendant's, in other words, the other driver's liability insurance when the damages in the PI suit exceed the net amount recoverable after satisfying the work comp lien, and also when the third-party defendant's insurance limits are too low to fully compensate all damages. So don't worry, we have an example, as I know that's kind of arcane and complex. So here's an example of when this bill would come into play. Officer Dan is hit by baby driver, and he sues baby driver in Superior Court. The city has a work comp lien for $20,000. Baby driver's policy limit is $30,000. Meanwhile, Officer Dan wins that Superior Court lawsuit, and his PI suit has damages of over 50,000 bucks. The end result under Senate Bill 487, the city would not be able to subrogate their lien of 20,000. And the reason why is that the policy limit doesn't cover the damages, and also the damages and the PI suit would exceed the net amount recoverable after satisfying the work comp lien. While we're talking about presumptions, let's talk about this peace officer presumption for state hospitals. This one affects Labor Code 3212.2. Anytime you see 3212, by the way, think presumptions. That's where all the presumptions, or most of them are, not all of them, but quite a few are. And so extending this heart presumption to peace officers for state hospitals would mean that the compensation that is awarded for heart trouble includes full hospital, surgical, medical treatment, disability, and death benefits. So that would be extended to peace officers who are working in state hospitals. Not easy places to work, as I'm sure we can all agree. Moving on to Senate Bill 230, again, while we're talking about presumptions and difficult places to work, everyone likes going to the airports on Thanksgiving, right? Not so much. Well, anyway, commercial airport firefighters, they have a tough job. This bill gives them the same presumptions that firefighters at the DoD or NASA get. And so some examples that are mentioned in the bill here are cancer presumptions and PTSD. And the reasoning for this is commercial airports have higher cancer risk, such as exposure to jet fuel, and also higher risk of a disaster that could cause some PTSD. And hopefully we don't have any more crashes this year. There's already been too many this year. So hopefully this presumption doesn't get brought up too much and everyone's healthy and happy. While we're talking about firefighters and police officers, this bill extended the age of children of firefighters and officers who die. It basically extended their ability to stay on their parents' group health coverage. So in the past, before this bill, they could stay on their deceased parents' group health coverage through 21. This bill extends that through age 26. And that's understandable. Moving on to this one is going to affect your notices. So those notices on the walls in the break room, for example. So Senate Bill 294, which was signed into law, establishes the Workplace Know Your Rights Act. And so it would require the California Labor Commissioner to create a new template notice notifying workers about their rights. So you're going to have to take the old one down and put this new one up. It also requires employers to notify employees' emergency contacts if the employee is detained or arrested while at work. And the example that immediately came to mind is if ICE raids the workplace and arrest people, the employer's got to notify the emergency contacts and let them know. I can't just let them sit in the dark. And so, while that is extra work, I'd say that's fair. I get it. Senate Bill 20 pertains to stone slab shop owners. This is another kind of notice area. It requires owners of slab shops to state in writing that they've provided appropriate training to employees who cut, crush, or machine stone that contains at least 10% silica. And this has the admirable goal of reducing silicosis. So hopefully, or the aim of this bill is for slab shop owners to ensure that they are providing that training to employees who are working with stone. So we already touched on this first stalled bill. So this next section of the presentation are bills that didn't make it through in 2025, but could come up again in 2026. So we already talked about the PEOs. Another one that came up that was stalled in 2025 is AB 1048. Now this one would have impacted how IBR writes their decisions. So when independent bill review writes a decision, and they're run by Maximus, and they say, this invoice or this bill is worth $5,000, and then they cite how they got there in the fee schedule formulations. If they applied a contractual discount, a physician could question, well, wait, IBR, where'd you get that discount from? And you've better prove that up. So IBR would have to provide the medical provider contract showing where they got that discount from. So this bill stalled in 2025, but I could see it coming back up in 2026. And while stuff like this seems a little boring and arcane, it's also stuff like this that causes the WCRB to point to higher cost and higher medical spend. So I could see this bill being slipped into a bigger, broader omnibus legislation in 2026. But yeah, it's something that could impact medical spend. Another thing that could come up in 2026, this bill, AB 1209, stalled in 2025. It would have required employers who were licensed under the or the Marijuana Act to prove to the DWC that they have workers' compensation coverage. This bill would have also given the DWC the authority to help those same employers establish a compliance schedule and also help them find coverage. And finding coverage is not always easy. If costs do keep on going the wrong direction, then maybe more carriers leave the state. And this batch of employers maybe has more difficulty finding coverage. As we discussed earlier, finding coverage is good. Otherwise, the liability just gets shifted elsewhere. So this bill had an admirable goal, and I could see this one brought up in 2026. Another one, we've seen over the last 5 years talk about a statewide MPN. So this bill, Assembly Bill 1498, would have created a statewide MPN of doctors able to treat in the Central Valley. And the way this one was written is the carrier or defendant's MPN would apply first. And then if the carrier's MPN couldn't treat the applicant within 30 days of that first request, then the applicant defaults to the statewide MPN, which is probably going to have a lot more doctors than the carrier or employer's MPN. So we have seen this come up every few years, ways to get around the MPN. I wouldn't be surprised to see this proposed in 2026, but I'm not sure it would become law. I could see this getting a veto or frowned upon by Governor Newsom in his last year. We already talked about this one. Senate Bill 555, this one also stalled in 2025. This one would have increased permanent partial disability payments based on COLA adjustments, which are currently applied to Social Security benefits. This was held in committee. I could see it definitely being revived in 2026. And while we're talking about the Assembly Insurance Committee, for example, I remember comments being made by the chair of that committee a few years ago, pointing out that when it's Governor Newsom's last year in office, he did have some goals for workers' compensation that he wanted to achieve, and that his last year in office, you might see some legislation aimed at the governor's goals. So that's another reason why we're anticipating some bigger bills in 2026. Now, Senate Bill 632 also stalled in 2025. This one would have created a rebuttable presumption for COVID-19 for hospital employees who provide direct patient care in a acute care hospital. And so this would have effectively reinstated the COVID-19 presumptions for hospital employees. And as you recall, those COVID-19 presumptions expired on January 1st, 2024. But we have seen this come up every year too, that there's a new presumption bill for COVID-19 and other conditions every year, and it seems to stall or get vetoed and not do so well along the way. But again, that is a topic we could see come up in next year, as it seems to be brought up every year. Now, I did want to finish by talking about another big decision that came down from the 4th District Court of Appeal. That's the Wayne Gandy decision. And this is a published decision, and it impacts sports law cases. So the 4th District Court of Appeal, they ruled that the appeals board lacked jurisdiction over Wayne Gandy's workers' comp claim. And Wayne Gandy, you football fans may remember him as being the Rams' first-round draft pick in 1994. And for those of you who know your football, what year did the Rams move from Los Angeles to St. Louis? 1995. So Wayne played for the Rams in 94 in LA, and then he moves with the Rams to St. Louis in 95 through 98. And Nasir, did we have any questions?
Yeah, I just want to remind everyone that the San Francisco 49ers won the Super Bowl in 1994. Thank you.
I'm not sure who that team is. I don't believe I've heard of them as a Arizona Cardinals fan who is still smarting from the loss to the 49ers on Sunday. Anyway, yeah, the Niners were excellent. I believe that was the Steve Young quarterback year. So yeah, Wayne Gandy, this big offensive tackle, 315-pound dude, plays for the Rams for 94 through 98, and then plays the rest of his career for the Steelers, the Saints, and Falcons. Keywords, non-California teams. So the procedural history in this case, at trial, the trial judge ruled that the appeals board lacked jurisdiction, and he cited this labor code, 3600.5. The appeals board reversed, saying the appeals board does have jurisdiction due to athletes who ever signed a contract in California or with the California team. That gets appealed up to the 4th District Court of Appeal. And the District Court of Appeal says, whoa, 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 Wayne Gandy's facts did not satisfy the statute, which we have here on the books. And that statute, Labor Code 3600.5, bars CT claims where the athlete was hired outside of California and the athlete played less than 20% of their duty days in California. Well, the team that was on the hook The last year of the CT was the Atlanta Falcons. Well, they hired him outside of California. And then also, if you look at Wayne Gandy's career, he played less than 20% of his duty days in California. Now, the District Court of Appeal looked at the next part of that statute, subsection D of that labor code. And it says that the appeals board has jurisdiction where an applicant completes 2 or more seasons for a California team, or applicant has at least 20% of his duty days in California. Now, remember, the Rams moved, so Wayne Gandy only played 1 season for a California team. And then from our last slide, we know that he played less than 20% of his duty days in California. The other requirement under subsection D is the applicant has to have worked for less than 7 seasons for non-California teams. And please recall that Wayne Gandy played for more than 7 seasons for non-California teams when he played for the St. Louis Rams, the Steelers, the Atlanta Falcons, and also the New Orleans Saints. We can't forget our beloved New Orleans Saints. And so with that being said, I believe we are near the end of the presentation. If you do have any questions, feel free to contact us and ask us any questions about any of the bills. We will have that blog article posted later today with a lot of information about those bills and easy to click link throughs to those bills if you want to look at them yourselves. And Tammy, let me kick it back to you.
We have a couple minutes left here. Nasser, do we have any other questions? I wasn't sure if we had any questions.
Yeah, there's some good questions that came in. Just one quick one, John, before I get to the longer one. On the SB 487, no cashback in that example. Does that mean no credit? No credit can be applied to?
Yes. So, well, as far as that, let me take a look at the specific statutory language. While I have read all these bills multiple times, that's a good question. And I think you may not be able to get that credit. But let me double check that statutory language, because as always, the devil is in the details.
Sure. Thanks, John. And a quick one that I think it encompasses a lot of what a lot of us deal with every day. But one question that came in from Kelly Long: there's a lot of discussion for legislative change involving amended applications, adding cumulative trauma injuries, bringing in, for example, psych and dental. Any insight regarding potential changes that might be impactful to defending these claims, battling higher impairments and or exposure to medical care? Hopefully the legislature, frankly, in my opinion, gets involved and helps limit that. That's why when the legislature did come in a few years ago, barring any post-2013 claims as far as Labor Code Section 3208.3, limiting psych being amended to every physical injury possible. But that's something that the legislature needs to wake up and respond to. From what I'm hearing across the state, it's more prevalent in Southern California, where you're having the multiple panels being added more than it is right now in Northern California. But it's just a matter of time, I'm guessing, before that expands. But in my opinion, the legislature needs to get involved ASAP, because otherwise, what's the whole point of having that change that happened a few years ago if everyone's getting around it?
And Nasir, the data from the WCRB, they actually mentioned what you talked about, the CT claims in Southern California being a cost driver and having greater severity.
Yeah.
And I can comment on that. Last few years, we've had a wish list at the end of this presentation. This year, we actually didn't even have time to do that. But on last year's wish list was for the legislature to get involved as far as additional panels. For instance, I can give you an example of a case where applicant's attorney argued really hard for an internist QME to address the applicant's diabetes. And then they don't like what the internist QME has to say after he reviews thousands of pages of documents and after his deposition. So then they argue, well, we need an endocrinologist QME, basically doctor shopping. And I think that there does need to be a greater rule set that every claim cannot just have endless panels. And the example I'll use is every claim is not a cancer claim. You could plead cancer on every single claim. We don't know if the applicant has it or not. They've never seen an oncologist before in their life. But as we all know, every claim is not a cancer claim. why should all defendants have to pay for a oncology QME? It doesn't make sense, and it's not sensical. So I do wish that the legislature would tackle that. As far as CTs, one solution I have proposed in the past is that there could be like a 2 or 3 year statute of limitations with exceptions for diseases that take a long time to accrue in the body. So you could have a 2 year statute of limitations on CT claims, for example, and just have a cancer exception, for example. I think that would be fair to the poor folks who have cancer, and still address a post-term CT that's filed 4 years later.
Sure. And that's a 0.00001% where cancer actually exists. The 99.999, it wouldn't be relevant. So your point's definitely taken, John. Thank you.
And we are right at 1 o'clock, so we don't want to keep you late. I just want to thank John and Nasir for today's presentation. And I just want to thank you all, whether this is your first webinar with us this year or whether you follow us all year long. We so appreciate you attending our webinars. We hope you learn a ton from them. And we are looking forward to seeing you all in 2026. Have a wonderful holiday season, everybody. Take care.
Thank you, everyone.
Thank you,
Bye-bye.
everyone.
Thank you. Happy holidays.
Happy holidays.